I'm going to make sure that everybody is awake. Today we are talking about listing documentation. It's very important. I just wanted to stress the fact that when you are a good listing agent, you try to keep up all your paperwork in line. And when you go to the listing appointment, you should have all of the disclosures ready, available. Make sure that you already do your part, meaning whatever has your name, your company name, your phone number, your email, fill that out, okay? That way, when you get to the seller's house, if you're doing a in-person appointment, all you need to do is sign here, sign here, sign here, and they're the ones signing, okay? Now, remember that the law says that every time a client signs a document, you have to give them a copy. So what I usually do is I print two sets, one with both of them will have my signature on them, and then I just hand the other one, the one that is not signed, to the clients, and I said, everything that you're signing, it's right on this package. And sometimes when I come back to the office, I will scan it and email a full set, and I tell them, hey, this is a full set of everything that you sign and I sign. And then you will be in compliance with the Department of Real Estate rules and the laws in the state of California that all contracts or anything that you sign, you are entitled to receive a copy right away. There is all kinds of ways to do it. Of course, if you're using an iPad, if you're using the mobile zip form, people can sign it. The moment they sign it, they already receive an email of every document that they're signing. So, but the importance of getting all the documentation is that if you were to take a hot listing today, tonight, you take a listing and you got all the disclosure forms, and tomorrow over the weekend you get an offer, you can immediately send all the paperwork to the buyer's agent and get things going right away. Time is of the essence in a real estate transaction. So it's very important that you get all the paperwork upfront. Also, I believe that when you are making a relationship with a seller, it is honeymoon time. They will sign, they will complete any paperwork at that time. They're happy. They have made the decision to sell the property, and they will sign all the documentation. It is very hard after they're taking less money, after the buyer's requesting repairs, that they want to sign documentation. They don't, what is that paper for? I don't want to sign anymore. You know, they get a little bit of buyer's remorse or whatever, seller's remorse, and then they don't cooperate and sign documentation. So it's very important that we take a listing, that we take all the documentation that is required for them to give to a buyer. And that way, once you receive an offer, you can give that to the buyer's agent and say, hey, give it to your buyer. Buyer signs it back and you bring it back to your file, and then your file will be in compliance. Most of the documentation, once you give to the buyer, you know, is in the contract, it says seller has so many days to give all the disclosures to the buyer, and the buyer has so many days to read them, approve them, and send them back. So make sure that you keep those that information, those days in your mind, and follow through with them. Okay, so what I'm gonna be doing is I'm gonna be sharing my screen. So I'm gonna go to the internet. And when I land on the internet, somebody's gonna tell me, hey, Cesar, I wanna sell my house. I get so happy. I go to my internet, and two things I do. I go to www.cbgeorgerealty.com, right? So when I go to www.cbgeorgerealty.com, that's one way to get to that spot, okay? I'm gonna go to the right of my screen and click on the navigation tab. Then I'm gonna go where it says agent login. I'm gonna go again where it says agent login. I am gonna land on a page that says enter protected area. When I hope everybody's looking at my screen. Enter the protected area, and this one is the where we put a password, and the password is very simple. It is George. So we type up George here. We're just letting people into the training. Welcome, good morning. We put the word George. We put okay. Oh. We put okay. The website answers you right. I put okay again, and I land on a page that has links. All of these ones are links. I know that when I click over here, because it's taking me to another website, you might not be able to see it on my screen. But if you were to click the listing and selling requirements, it brings you to the to the transaction zip form edition, okay? So I hope that you see that part. And then over here on the username, you type your first name, dot your last name, and then you put your password. If for any reason you forgot your password or you forgot your username, you could always retrieve it from here, okay? Do not sign in with your NAR Realtor username and password. Do not. Because what happened is that if you sign up with your Realtor name, when you sign up with your Realtor name, you do not land in the broker version. You do not land on the Coldwell Banker George Realty version. You land on the other side of the building, and you land on the CAR website portion of zip form. There are two. You guys, by being members of the Association of Realtors, have access to CAR zip forms, and by being members of Coldwell Banker George Realty, you have access to zip form broker version. So what I'm going to be doing right now is I'm gonna get out of here. I'm just gonna go to a fresh tab. I'm gonna close this one. I'm gonna close the George Realty. I hope that you're seeing, and I can type www.zipformplus.com. And when I go there, I end up on the portal. I would put my first name, dot my last name, and then I will put my password. I have so many that sometimes I forget which one is it, but I think this one is the right one. Once I land over here, of course, I need to be a member of the California Association of Realtors. If you're not paying member, they will not give you access to the zip form. I'm gonna continue to my transactions. Sometimes my desktop looks a little different. Excuse me. Let me see if I can ask people to mute. I'm muting everybody there. Thank you. And I end up, my transactions are a lot of transactions that I keep over here. Sometimes I delete them, sometimes I don't. But this is a way that you can look at them. You can look at them by line, or you can look at them by tile, okay? If I go this way, it will give me grids, and it will give me, you know, training, Arcadia meetings, people that I do transactions with, or I create transactions. But I could always go here, download, and if I don't like the transactions, I can delete it. And let me allow these people to see. Whoops, what am I doing here? Okay, allowing the people. So what I'm going to be doing is taking a listing today. So I am going to create a brand new transaction. So I click on the brand new transaction, and it is gonna be a listing. So it is a new listing. It is a, I'm gonna enter the address of the property, 1604 Valencia, or one of the streets here, yeah, Valencia in Alhambra. I am with Coldwell Banker George Realty. This is gonna be a residential transaction. You can even put prospect or an active, and to me, I always put active because I believe I'm gonna take the listing. I am the agent. I belong to Coldwell Banker George Realty. And then here's the most important thing. If you don't learn anything about today's class, is that my templates is what you need to click. The drop-down menu will give you the templates that Coldwell Banker George Realty has selected, okay? So here we would have Coldwell Banker commercial lease application. No, I don't need that one. I need to be able to see and allow these people to come in, and I'm having a little hard time. Okay, letting Shirley and letting Thomas Wong come into the meeting. Okay, so the templates, as I was saying, the drop-down menu, I'm looking for a residential listing. So I'm gonna go mobile home listing, no. Residential income listing, no. Residential lease, no. Residential listing, no. I'm looking, yes, that's the one, residential listing. So I click on the residential listing and I would have it as my template. That's Coldwell Banker George Realty template. It will have all of the documents that can possibly, we can possibly use on a listing transaction. So I would save it. Once I save it, I'm gonna be moving from tab to tab to tab to tab to tab. It's very easy. I want you to practice and click on every tab and see what's out there so you would discover everything that you're doing, okay? So you can discover what happened on templates, what happened with documents, inbox, task. I don't use it. And then you need to learn them. If you go to help, you can find videos on how to train this into zip form version. So right now, this is a summary of my transaction. The property is not on the MLS, so I don't have an MLS, but auto-populated the address. Now, the second step that I need to do on this transaction is who is involved in the transaction. So number one is gonna be the listing agent broker, which is me, and I'm gonna be here on the seller side. So it's me, so I wanna make sure that all my information is completed. I'm gonna view myself, my data, and his full name. My name is Caesar, so I go there and I already have it pre-printed because I have used it before, but if not, you have to type it. Agent ID is your license number. I just repeat the license because this will auto-populate into the transaction. I work with Coldwell Banker George Realty. Coldwell Banker George Realty license is 011-21690. That's our corporation license number. Our office ID, we put the same license number. Email, I will put my email, ciaviles@coldwellbanker.com. My business number is the office number. My cell phone number, 757-5550. I can type it. Business fax. If I want people to bug Peter, I will put broker phone number. I'll put his cell phone number here, but I won't do that for today. Okay, so I'm gonna save. All these transactions from here will auto-populate to my form. The next one, I'm gonna pick seller number one, okay? And then on this one, I'm gonna start picking up, my seller, my famous seller is Sally. I love Sally. She signs all the documents all the time, seller, okay? Sally has a phone number, whatever, Sally at listing.com. She has a phone number, 555-5555. So all that information I can fill in about her. A caveat, if you are selling somebody that owns a property in a trust, a probate, using power of attorney, an entity, then you put here the name of the entity to the best of your ability, ABC Incorporated. And then over here, you need to have the name of the natural person that is representing that entity. And when you do that, it will create a representative agreement form in your transaction. And so the seller will be the company or the trust or the entity, and the person signing is the authorized person from that company or that entity to sign on behalf of that company. So now I have two parties to this transaction, the listing agent and company and the seller of the transaction. Then I move down the next tab, and it's the documents that I'm gonna use in this transaction, which is today's class. When I click on documents, they already auto-populated, okay? And you say, oh my God, do I need to fill in all that paperwork? The answer to that is no. You only need to fill the paperwork that applies to your transaction, okay? Sometimes, for example, in the form, think about it like a menu. You're going to a restaurant and they give you, your salads and soups, and then your entries, and then your dessert, and then your drinks and alcoholic drinks and the wine list. And you don't order everything on the menu. You just order what you want to eat. So you also have to think a little bit as a real estate agent and say, does this paper applies to my transaction? Like, for example, we're going to be selling a property in Alhambra. And if we go to the bottom of it, it says City of Los Angeles 9A report. Well, I'm not gonna eat that dessert. So what I'm gonna do with this form is I'm gonna come all the way down to the right. I'm gonna click on that one and I'm gonna delete it from my file. I don't want that City of Los Angeles. City of Los Angeles Department of Water and Power. I'm not gonna use that form. I'm not gonna eat from that menu. So I'm going to come over here and delete it. I mean, you can start by deleting by elimination, okay? Or you start going from the top and then you say, do this form applies to my transaction? Yes or no? If it doesn't, then delete it. If it does, then you need to complete the form. So now the cover sheet is very important for some people. I, Caesar, don't use much of the cover sheet, but some of you may like to use it to keep everything in organized way. So if you click on the cover sheet, the more information that you have in this form, the more that is going to auto-populate to your transaction forms. So here we have Sally Seller. If you want to put Sally Sellers, I think it was 1604 Valencia, we'll say that she lives there. The property is in the city of Alhambra, and you can start filling in the information. It is on the state of California, and the zip code is 91801, whatever, 918. If I type it there before, it's gonna be there. If you haven't typed anything in this form, nothing will be in the drop-down menu. The phone number 555. So the more information that you put in here, the better that it's gonna be. In this case, we only have Sally. She's a single woman. She's selling her house. If she was be married, or if she owned the property with her mother, with her husband, then we will have to fill in seller number 2, right? And then seller number 2 will be also signing. There will be an X at the bottom of every form. Because I'm only using Sally, I'm gonna take away the X, so there will be only one signature slot for Sally transaction. Then the property is on Valencia. If I wanted to fill that is in Los Angeles County, I'm gonna put Los Angeles there. It is in California, that's the zip code. If I have the legal description, I can do it, or the taxpayer ID number, the assessor's number, not the day, hold it. The assessor's parcel number. So let's say that it's a 0045-001-011. Usually that's the format in the county of Los Angeles, 4 numbers, a dash, and that will refer to the page of the tax parcel number. The listing day, I'm gonna hope that the listing day is tonight. So I'm gonna put September 11. The expiration day, I'm gonna hope that it's gonna be 6 months from today. So September, October, November, December, January, February, March. So I'm gonna go all the way to March of 2021, and I'm gonna usually try to end it at the end of the month. I could always change that day when I go to the listing information. The listing price, I already have done my CMA. I'm gonna list it for, $6.99 or whatever price, so $6.99. All this information is gonna be populated to the transaction. I may or may not wanna put the mortgage. I don't know if I don't have it. This is a condominium, then you're gonna put here what are the association dues, if there is any transfer fees. And if you wanna use this transaction cover sheet as your document for your transaction, you're more than welcome, okay? If you wanna use title companies, home warranties, and then you're gonna prepare a counter offer, these things will auto-populate on your transaction, okay? So we move in our zip form by using the back button. You go back to my menu, my list. So I already took care of the cover sheet. The next document that is very important, it says, please complete and have the seller sign it. A lot of people in the Arcadia office are missing the seller's signature. I don't know if somebody told you that you're not supposed to sign it. By the rules of the MLS, by the company policy, the listing agent must sign the form and the seller also have to sign the form. So I appreciate those of you that are starting to do that in the Arcadia office, okay? So don't fall in the habit of not doing it. If you go here, we have a PDF of that form, okay? And I'm not sure that your screen will see it, okay? And then you have to print it and you have to, by longhand, fill it in. In the event that you want to go and find this form in the CRMLS website, you're welcome to do that. You can find the form there and you can fill it in there. But then remember, once it's completed, to import it here. You need to add that document back into this transaction. So you will delete this one and then go prepare the one, type it in your computer, and then import it once it's already completed to the best of your knowledge. Remember, you're gonna have to pre-complete this form based on information that you have. Then you're gonna go to the seller and ask the seller other stuff that the seller wants to have on that listing information, okay? The next document that we have is the seller's instruction to exclude the listing from the multiple listing service, okay? Sally tells me, Caesar, I don't wanna go to on the MLS for the next 1 week. I'm gonna paint, I'm gonna clean. Then you must have this form done. And there are 3 questions. Keep it for a period of 7 calendar days, right? Don't submit it to the MLS. Or you can do this, don't do it until, and there is a calendar until next Friday, September 18. Or if you happen to be a private person, a movie star that says, I don't want my house to be in the newspaper, I don't want nothing, then I can exclude it in the entire listing period on the agreement. It will not go into the MLS. You would have to do other types of marketing, okay? And they tell you, do not market the property immediately. Begin the marketing on the public on a certain day. So you can start marketing it on the 18th, okay? So those are instructions that you and the seller make a decision. That's why this form is blank, okay? And we are members of CRMLS. For those of you that belong to Coldwell Banker George Realty, we are members of California Regional Multiple Listing Service, and make sure that you input that in there, okay? This form, once it's completed, it will be signed by you, and your license number have to be placed in there, and my name's supposed to be populated there, okay? And the Coldwell Banker license will be there, and Sally will sign here at a later time and at a later date. So once this form is completed, I'm gonna move back and I'm gonna go to the next form, right? This one is the listing agreement. On the listing agreement, it's our main tree. You have heard me speak before, and I always treat the contract as the tree, and then all of the disclosures are like branches. Sometimes we need to cut a branch, and sometimes we need to put a new branch into this tree. But what I wanted to do is I'm gonna go to this document, and then I'm gonna go to the other documents. I'm gonna go fast on the disclosure regarding real estate agency relationship. This is non-contractual. By law, anything that you see civil code, it's by the law of the state of California. It is not by Peter's choice, it's not by Caesar's choice. The form has to be filled in because the laws in the state of California require it, okay? If it is an advisory, I'm sorry, an advisory is kind of like grandma telling you, please don't go out. There's smoke in the air and you're gonna catch a cold or you're gonna get respiratory problems. That would be an advisory. Or don't go near Monrovia, there is a fire and you're gonna be disrupting the traffic. Let the fire trucks go by first. You know, that's an advisory. So this is a disclosure. Anything disclosure, it's by law. Anything advisor is by policy. We need to do it. The company wants to do it. CAR wants us to do it. That way we stay out of trouble, okay? So on this one, Sally is the seller. Sally will sign it, and then Caesar will sign it, or you will sign it on behalf of Coldwell Banker George Realty. And then if anybody wants to know the entire agency law, the disclosure of agency relationship, it's on the civil code. And if these letters are too small, you could always Google, go to the civil code section 0.13-2079-24 and read it, okay? And understand what you're doing. You are being the esquire, you know, when in the medieval times, the two lords were fighting, you're the esquire, you help them. That's what you are when you're representing a buyer or when you're representing a seller, okay? The next form that is attached to our tree, to our listing, is the possible representation of more than one buyer or seller. What happened is the following. We the agent, is one agent. Coldwell Banker George Realty is called the agent. And now we are 400 agents, 375 agents in the company. We may be representing a seller with a similar type home. And we promised that seller that we were going to sell that house. Well, I am making a promise to this new seller. I'm going to sell you a 3-bedroom home. And then if I don't sell it and that house sells first, he might say, hey, you're not doing your part. That's the reason why we're telling them, hey, there's going to be other sellers that we are also serving that may have a house to sell. And don't get upset that we don't sell yours right now because somebody from the Puente office may be selling a house from the same 3 bedrooms, 2 bath, around the same price, around the same neighborhood. So, and then we get a consent because the client needs to give us permission to represent other people, okay? So actually we tell them, hey, there's gonna be a possibility that we represent more sellers and that you're giving me permission to represent you as well, okay? So here, Sally will sign that permission and Coldwell Banker George Realty, Cesar Aviles will sign again. Now we are going to be using this form when we get a buyer. So we're gonna give this form to the buyer and the buyer is gonna sign it and then return to us, and then we're gonna put it as part of our file, okay? If for any reason you get this form, okay, and it is signed by the seller and is in our file, and we get this form signed by ABC Realty and the buyer, we get that form and we put them together. They read exactly the same, only the signature boxes are, it is considered to be signing counterparts. One party signed it on one paper, one party signed it on another paper, but if both papers read the same, it is considered to be the same form. And we can give copies of those to the other party as well, okay? The next form, because we live in the state of California, Los Angeles County, it is the fraud capital of the world regarding recording documents and getting loans against properties because property values are pretty high and it's worth it to go and you don't go to other little cities where the prices of home never go up, but over here the price of home goes high. They can sell it, make a profit. So there is fraud going on and they're using wire fraud on computers. We were once a victim of wire fraud. The company, our transaction coordinator in Arcadia had an issue. They sent an email. All of a sudden, the buyer sends the money by wire to the wrong wiring company, and we had to do FBI and the whole bit. So right here is information about telling the sellers that there will be wire fraud and electronic. Be careful. Make sure that they obtain the phone numbers of the escrow company and not to fall victims of wire fraud. I will recommend that you guys read all of this documentation and become pretty familiar. I mean, I don't believe that I have to go line by line by line by line. Of course, if you have a question, I'll be delighted to try to help you with it, but you guys have to read it because you guys and the clients are gonna be signing. So Sally will be signing this, and then the buyer also will be signing the same form, and it will become part of our file before we close the escrow. Now, ta-da-da-dan, what we were waiting for, right? And what I'm gonna do on this one, I'm gonna put it on full screen so we can read it. This one is our agency, right? Needs to be signed by Sally, needs to be signed by the agent. Read the entire civil code. Possible representation of more than one buyer and seller. They could be multiple buyers, they could be multiple sellers, and we could always be dual agency. Remember, dual agency is created when the same license, Coldwell Banker license, it doesn't matter whether you are in the same office or in the same company, we will be dual agents. if Lori is the listing agent and I am the selling agent, we will have to, on our confirmation at a later time, check the boxes that says that we both represent both buyer and seller, even though I've never met Lori's client, okay? The next documentation will be wire fraud, and that we explain that to you. And now we come to the residential listing agreement. Make sure that it is dates, you don't miss anything. So today's date, we're preparing this one. Sally Seller is giving Coldwell Banker George Realty the permission beginning on September 11, 2020, ending at 11:59 p.m., March 31st of 2021. That is my listing period. I have the right to advertise, sell the property, market the property, and there are other duties that I need to do. Now, once we sign this document, the seller cannot cancel unless Peter, the broker, gives permission to cancel. This is like a marriage. You're married. You would need to divorce by signing another divorce decree. And for those of you that might have gone through that sad moment of divorcing, it is not easy. There is lawyers and cancellation and all. Exactly the same thing could happen on a residential agreement. It is a contract. They're giving us exclusive authorization and right to sell. That means that no matter who sells the property, if the seller is watering the lawn and somebody says, I'd like to buy your house, and they sell it, we are entitled to commission, okay? If the seller gives it away to his son, we are entitled to commission, okay? During that time, to sell the property at 1604 Valencia, located in Alhambra, 91801 with the assessor's parcel number. Of course, this is a fake parcel number. That's not the one. If this is a mobile home or manufactured home, you will have to check this box. This one is not a mobile home, so we don't check the box. In the event that we're selling a probate, in the event that we're selling, then we will click the box. When you click the box, there will be additional addendums, okay? That will include additional terms on the transaction, okay? Now, we are listing the price of this property at $699,000. That's what I put when the phone, I told the sellers, hey, I want to sell it for this much money. And the seller said, no, 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 Caesar, I don't agree. And we do a CMA, and I wanted to list it for $725,000. So I agree, and I said, fine. I put the price, it will change here, okay? I could also cross it out with a pen and put the price and put initials over here. It's quite all right to do it. In the event that there will be other terms, okay, you're welcome to write them here, okay? For that, any other terms that you and the seller agree on. Point number 3 is how much are we getting paid? The contract already comes up with a 6%. Some of you may be even afraid to say 6%. I know that there are people in the call that would like to say 7%, and you know, and it's fine. I love to charge 10%. Unfortunately, in the San Gabriel Valley, there's been a commissionectomy. They're cutting commissions, and some of the agents are doing stupid things, in my opinion. But the price that they charge is just the price that they charge. Coldwell Banker George Realty is a full-service real estate company. We would love to charge a 6%. This way, we will have all the tools, all the marketing, all the internet, all the newspapers to advertise your property and get you the most money. The agents at Coldwell Banker George Realty have permission from management to cut the commission from 6 to 5. Anything less than 5 needs to be discussed with your manager. Okay, so I'm gonna leave it at that. If anybody wants to do a discount commission and you wanted to put something like 3%, we will not take it, okay? We would like to take the minimum that I've seen. It will be a 4%, and it depends on the area, depends on the price of the home. On anything below $1 million, I think that you're going crazy by doing it for any less than 5%, okay? I understand over $1 million, commission goes to $50,000. I mean, you can buy a car with that, you know. $50,000. And the sellers think that we have no value. So, but I believe that we have the value. We bring a lot of value to the transaction. Now, this comes up auto-populated. It says that if within 180 calendar days after the end of the listing period, so after this day, after March, I still have 180 days to protect my commission. In the event that I have negotiated a offer, counter offer, and it didn't go through. But if the same buyer comes along within 6 months after my listing and they are the ones buying the house, I may be entitled to a commission as long as I give the seller the list of the people that I negotiated. If you don't give the seller that list, then this thing is out, okay? It's up to you to do it. Very hard to enforce it, but it is in there, okay? Or, okay, A, 1 or 2 or 3. If without the broker's prior written consent, the property is withdrawn from the sale. So the seller says, hey, I want to take it off the market. You could say you owe me my percentage. If they convey the property, they transfer the property to a brother. If they decide to rent it out, okay, otherwise transfer or made unmarketable by a voluntary act of the seller during the listing period of any extension. So meaning if the seller decides, hey, I want to rent it out, you are entitled to your commission. We usually don't do that because sometimes we will become the agent of that rental agreement and we get paid a little bit and we wanted to keep a nice with the seller. And so we management allows some of this to happen, okay? Sometimes you might take a listing for lease, for sale, whatever happens first. So remember, if we lease the property, then we have to cancel the contract for sale. And we will do that. Or if the property sells, we will cancel the listing for lease, okay? Now, Coldwell Banker George Realty, besides the commission that we charge, we like to charge a administration document compliance fee. It is not a transaction coordinator fee as some people want to make it believe. It is a fee. This money allows Coldwell Banker George Realty to give you broker version of zip forms, so that way you can use it. It also gives you zip forms, which is a paperless platform that stores all the documentation for many years. In the event that the seller wants to get copies of the transaction, we will gladly give it to them. If the seller wants, if we did not collect the $295 and they want documents, then we could always say, well, pay me $295 for research fee and I'll go to the basement and go get the copies of the forms, okay? So this is money does not go to no transaction. This money comes to the Coldwell Banker company, okay? And we are trying to enforce it to the best of our ability. So please, this money gets charged to the customer. If the customer doesn't pay, in some cases, the agent will have to pay it, okay? And then number D, it says, seller has been advised of broker's policy regarding cooperation with other brokers. And what we're gonna be doing is telling them that we belong to the MLS and we are going to pay them half of what we're collecting. So if we're collecting 5%, we are going to be paying here 2.5%, right? If you feel that you don't want to pay 2.5 because you're doing and you want to pay a 2% MLS, it's quite all right. Or if you're charging here 6% and you say, well, I'm the one charging 6% because I'm doing the marketing, and over here I'm going to pay 2.5, you are welcome to do that, okay? I personally don't like that. If I make 6%, I want to pay my co-op agents half of what I'm making, because today is for me, tomorrow is for you. And sometimes I'm gonna be on the other side of the transaction and I like to be treated fairly. To me, that's the way, that's the spirit of the realtor originally. That's how come we become a multiple listing service where we share our commission amongst a real estate agent. I know the world has turned out into a little ugly place to live, and people get so frantic with commissions and people fight for $1 or 1 penny. unfortunately, that's the world that we live in here. Seller represent that the seller has not previously entered into another listing agreement. So the seller is saying, I don't have another broker signing on the property, okay? And also the seller warrants that he has no obligation to pay other commission to any other broker in this transaction, okay? Now, that is page number 1 of the listing agreement. I'm gonna move a little bit faster. If you have a question, put it on the chat and then I'll address it at the end of this little segment, okay? Of course, when you took your real estate license, what was excluded or included? If you wanted to exclude, the light fixtures, in the living room, you certainly can do that. If you want to exclude the fireplace equipment, that's up to you. Or if you want to include and you say all appliances, are included in the sale, you can put it in there. Make sure that there is a clear understanding. A lot of people don't tell you, but anything that is excluded, it is excluded. Make sure that you do it at the time of the contract as well, okay? And you put it on the purchase agreement or you put it on a counter offer. Even though it's on the listing, this agreement is between you and the seller, and then you might end up paying for the buyer. Now that we have houses with solar power, alarms, tanks, water softeners, right? Or any other equipment, they may not be owned by the owner. This is something that is leased or rented, or it has not been, it's a lease. Make sure that you put it in here. Or if the solar power hasn't been paid, maybe sometimes they took a loan for hero loan. Make sure that some of those heating, ventilation are included or not included. Make sure that it is spoken to the seller and there is an understanding at the time of close of escrow who's gonna pay for those items or who's gonna remove those items, and that the buyer is aware that the house, even though right now it has an alarm system, when you buy it, it will not, because the company that we make monthly payments is gonna go and take off all the electronics and all the equipment, okay? The property is gonna be listed in the multiple listing service. I belong to the CRMLS. In the event that it will not be put on the MLS, you can check it out and put it on the MLS. Benefits, okay? This box is just to explain the seller that there are great benefits in putting the property in the MLS. The seller will initial here that they understand what the MLS is all about, and the agent will put their initial here. I also see many listings that you guys bring where the seller sign and you forget to put your initials. I'm gonna start being a little bit more critical of that and maybe rejecting listings. So please pay attention to make sure that everything is initial. And sometimes we relax and that's when problems happen, okay? Is there a problem if I don't have an initial? Well, there is no problem if there is no problem. But the moment there is a problem, boom. Oh my God, the attorneys start checking every single document, and then we, Houston, we have a little problem. I don't want that to happen. In the event that you are using this coming soon, make sure that you read the MLS rules on the coming soon. I don't agree on that. If I take a listing, the reason to take a listing is to put it for sale and to get the most money for the seller. I believe that if you put the property on the MLS, you're gonna get the most sellers because it is exposure. So you're gonna get, when you put something coming soon and you try to double end it yourself, you might not be getting the highest price for the seller. At least that's my explanation. That's my position on this. There could be a lot of arguing. There's a lot of arguing at the CAR and NAR meetings as to coming soon marketing. Sellers give instructions to the broker, okay, that not to go into the MLS. We already discussed that form. So you have to put over here and a date that it doesn't go to the MLS. Clear cooperation policy does not apply. This is something that has to do with the coming soon, not to market on the public. You need to read the CRMLS rules and follow through with this one, okay? MLS data on the internet, right? The MLS rules allows MLS data to be made available into the internet. property or property address, sellers can instruct the broker to have the MLS not to display the property. If you're gonna put it for sale, you put it for sale. That's at least mine, but there are opt-outs. You know, the seller can say, I don't want this in there, or I don't want photos of my kids' bedrooms or things of that nature. You could always do that. If you checked over here, you can opt out of having your property listing not to show up on the Zillows and the Trulias and all of the website, but I think it defeats the purpose of putting the property up on the for sale. So if the seller says, I don't want the property to be on the internet, then you have to click this box, and then the property will be exempt from going into the internet. Okay. There is other representations made by the seller that he's not in bankruptcy, that there is no government letters. Unless there are some letters served upon them, he needs to let us know that he is aware of it. You know, if they have any special assessments affecting the property, seller shall promptly notify the broker in writing if the seller becomes aware of any of the problems. Like, for example, if let's say that you're selling a property up in the foothills, you know, with no fire, and you take the listing and you ask the seller if there is any notices, and the seller says, no problem. But then a notice of fire department says, you got to clear the hill. Fire season is coming, and they give them a letter. And if the seller doesn't do it, the fire department hires people to go and clear that, and then they put a lien against some properties. In some parts of Altadena, they do that. In some parts of Glendale, they do that. So if that happens, then the seller needs to let you know. That way, that will not delay the escrow. Now, this one is your job. Number 10, it says broker, sellers, and duties. Brokers agree to exercise reasonable care, diligence to achieve the purpose. The purpose is to get this property sold. So we're going to put advertising. We're going to put flyers. Of course, pre-COVID, we will do open houses, and we're going to be doing all that kind of door knocking and marketing. Today, we can't do that. So we need to maybe virtual tours, do different things. Go with your cell phone and film the house and post it on your YouTube, you know? So those are things that are your duties to get the property available. And the seller needs to make the property available for showings. Reasonable times. Of course, you're not going to be showing the property at 3 o'clock in the morning. Okay, so make sure that you arrange with the seller when is the best days to show the property. Also, the seller is the responsible for determining the price that he will take the property. Even though we suggest, based on a market analysis, whenever the seller says, I'll sell my house for, you know, $699 or $725, it's the seller's choice. You know, the $725, seller chose to put $725, even though I recommended a $699 price, and I agreed to do that, okay? I also, the seller needs to provide reports, okay? They will pay sometimes for a termite report at the time of putting the property for sale, okay? Some areas, people buy a property inspection. The seller does the property inspection, and he might decide to go ahead and do some repairs based on the property inspection. When the offer comes along, they say, I took a property inspection with this company, and I fixed the following items. The other ones I'm not gonna do. So there may be a seller that wants to do that. It's quite all right. It is customary that the seller doesn't do nothing. It is a seller's market, and they're egotistically asking, as is, where it is, no repairs. You know, that's their choice. And then the buyer brings an inspector, and then the buyer can request repairs. The seller doesn't have to do that, but the buyer has the right to request repairs. If this was property in a homeowners association, if it was a condo, then you would have to request those documents to come in, and then the seller have to pay for those documents, okay? The deposit, the broker is authorized to accept and hold on behalf of the sellers a deposit. We don't do that anymore. Coldwell Banker George Realty has chosen that if you are writing an offer, the check should be payable to the escrow company. We don't take a check on our hands, or they're gonna wire money. They are gonna be doing it within 3 days after the offer gets accepted. So that is our policy. We do not have trust accounts, and we do not want to keep the record. So it is pretty the Department of Real Estate is pretty, checking on the trust accounts and logs of checks. So we don't want to take checks. The agency relationship, they mention it again. The box is checked, so there's a disclosure regarding real estate agency relationship. The seller broker shall represent the seller in any resulting transaction. So we are the seller's representative at this time. There is a possibility that there will be a dual agency. Okay. On the next page, we put the address, make sure that we have the address on the property. The confirmation of agency will be done at the time of the purchase agreement, okay? Right where the sellers execute the purchase agreement. There will be competing sellers and buyers, so that's the reason why we put the possible representation, more than one buyer or seller. We already have the form. Make sure that you tell your sellers to have their insurance, and we are not responsible. Even when we were doing an open house, if somebody comes in and they steal something from the open house, we are not responsible for that. Of course, they can sue us, but we ask the seller to please keep their insurance policy in place. We also tell them that the property is going to be photographed and it's going to go to the internet. Of course, if they object, they will have to check this box. I don't want my photos on the internet. I think it defeats the purpose of putting the property up for sale. The sellers acknowledge that prospective buyers coming into the property may take photos. Remember, even in the Sixtine Chapel, in a museum, in the New York museum, Metropolitan Museum, it says no camera, no this, and there is so many pictures of the ceiling of the cathedrals or the Mona Lisa, in the Louvre in France. A lot of people take pictures of the Mona Lisa, even though it says no pictures. Well, we can't stop buyers from doing that, but we need to, let them know, even if the seller says, seller instruct broker to publish in the MLS that taking photos, right, is only for the appraisal or the inspector. Okay, no buyers can take picture, but how can you stop it, right? The only problem will be if the photo gets published, then because of copyright laws, they can go ahead and sue them, I guess. That will be the, for misuse of photographs. If the seller put a lockbox, make sure that you're using an electronic lockbox. Do not use a combination. Somebody can grab a combination and they're not safe. You don't know who was the last person that had the combination and took the keys and something happened. The electronic lockboxes are very secure, and it gets registration as to who, when they open, when they close, who was the last person at the lockbox getting the key. The same thing goes with a sign. We get a permission from the seller to put a sign for sale. It is the cheapest way of advertising. We put a sign for 6 months. Where in the world can you put a big for sale sign for 6 months at a very inexpensive price? So you're advertising our company, you're advertising yourself. So it is, we ask the seller to let us put a sign. Excuse me. Equal housing opportunity. Of course, every realtor at Coldwell Banker George Realty is colorblind. We do not discriminate based on all the protective laws and clauses in the state of California. There's about 27, national origin, immigration status, color, race, creed, sexual orientation. We do not discriminate under no circumstances. So equal housing opportunity is what we do. Of course, the form was created by attorneys. They want to make sure that they get paid in the event that somebody hires an attorney to sue somebody. If they win, they want to get paid their money. Reasonable, but I do not know what's reasonable for an attorney. Now, in the event that there are other terms, if this was an REO, real estate owned, this is when a bank has taken the property from a foreclosure and they decide to sell it, they are exempt from providing some disclosure. So there is a form. REO listing. If this is a short sale, meaning that the balance of the loan is bigger than the selling price, there will be a short sale listing information, and there is a form that needs to be filled out. If this is a trust, there's going to be a trust advisory attached to this listing, okay? Or if there's going to be the seller intend to include a contingency to purchase a replacement property as part of any resulting transaction. So if the seller is selling their condo and they're going to be buying another property, they can click this box and they have the intention. When the offer comes along, then the seller gives the buyer the paperwork that says, I will take your offer as long as you let me go find another property, okay? So there is another form for that, okay? On the following page, it says that this listing that you are taking, any agent, the manager has the approval consent. So if for any reason you go out there and take a listing that the company think that is a risk of taking, the management has approval to say, I'm sorry, we don't want to take that listing, either too low commission or too high of a price. We don't want to spend money on advertising on something that we as a management believe is not going to sell. Or if the property is involved in a big lawsuit, or if it is a very complicated transaction that we may not be, it's going to cost more money, more energy than the little money that we're going to collect or the risk that we might take, okay? Successors, in the event that this, the seller passes away, any successors of the seller will be binding on this listing. In the event that we have disputes, fights, we would agree to go to mediation or mediation terms, okay? So there are terms to go to mediation. In the event that we wanted to do arbitration, then we will have to sign an arbitration form with the seller, okay? Now, anything that I've spoken, remember that real estate, it's in writing. So the entire agreement is what is being signed here, okay? All prior discussions, negotiations, agreement between the parties concerning the process are superseded by this agreement. So whatever is in writing is what goes. Anything verbal doesn't go. The seller is telling us that he is the seller and that he is authorized to sign the contract with us. If at a later time we found out that there is another seller, husband, wives, partners, and they say, well, we want to take the listing away. Well, the seller says that he has the authority to do that. So we might have some legal remedies for his telling us that he is the seller of the property. In the event that this is a representative capacity, if they're selling, a corporation is selling a house, a state, a trust, then we check the box and there'll be a form coming up to do that. The seller, Sally, signs over here, and I, the broker, sign, the agent signs right over here. That means we have a listing agreement. We have an agency, we have a listing agreement, we have a listing agreement. All the paperwork are branches to our tree. It is Coldwell Banker policy that we want to have everything together for our file. So please do not be a lazy listing agent. Get everything at the same time, as I mentioned at the beginning of this listing. Then this is an advisory. We tell the seller, hey, Mr. Seller, selling a property in California is a process that involves many steps. It is a complicated transaction. So please make sure that you will disclose the right way. Make sure that there are the duties, disclosures by law. 1 to 4 property residential units, you need to provide an NHD. You need to provide a real estate transfer disclosure statement. You are going to give us the environmental hazard, the earthquake guide. So all of these forms, we let the seller know that that he is required to provide these forms, and that's why we get them signed right now. Okay, later on, it becomes harder to get all of those forms. The TDS, the NHD, the lead base, military ordinance. We need to tell the buyer whether the property is close to a commercial zone, whether somebody died in the property. So all of that information, the seller needs to know that he is obligated to give to the buyer. The state of California is a consumer state, meaning the buyer is the consumer and the seller is the big rich guy that is taking advantage of the poor buyer. That's the mentality of the people that make the laws in the state of California, okay? So there it is, death or other disclosure, okay? Condominium, you need to tell the buyer if this property has common interest subdivisions, okay? Any legal terms, they make the description over here. Contract terms and condition. A buyer may request to have repairs of the property. Your decision whether or not to comply with it, okay, with a buyer may affect your ability to sell the property at a specific price. If you say, I want to sell the property as is, you may not get as much money if you sell the property fixed up and in good shape, okay? That's up to you. It is a seller's market. Over here, if you forget, look at it, you need to click and put the date, today's date. It did not auto-populate it, but so you're looking at your transaction, you're reviewing everything, make sure that all the boxes are checked. Over here, we don't have to fill in anything. It's just mumble jumble. Mr. Seller, we will be withholding taxes if you happen to be a foreign person. If you happen to live in New York or live in Texas and you own a property in California, the state of California consider you an out-of-state person and they want to withhold taxes, okay? Again, prohibition against discrimination. This is not only because we, Coldwell Banker agents, do not discriminate. We are telling the seller, you, Mr. Seller, do not have the right to discriminate, okay? So if the people bring green money, we have to sell it to whoever buys it. In the event that you're in a city that the government requires repairs, it says some cities and county governments may impose additional requirements. Like if you're in El Monte, San Marino, Pasadena, some of the cities that we sell property, Azusa, they require point of sale inspections. Make sure that you, Mr. Seller, is aware that you have to comply. It's not just because Caesar wants you to sell it and have these things, or the buyer wants you to do it. No, the government of the city where you live, where you own the property, has rules that you need to follow, Mr. Seller, okay? And then you live in a state of, in California, a lot of laws. We live in the United States. This is a federal law that every house built prior to 1978 may have lead, and we need to explain to the buyers. The Environmental Protection Agency, for those of you that are green people and you love the EPA, there is the website, and you can tell the buyers and the sellers to go and visit those places. We also remind the seller of legal tax consequences, okay? When you sell the property, if you make a lot of money on the sale of the property, you may be subject to taxes. If you have placed your brother-in-law in the title when you sell, maybe the brother-in-law has some tax consequences, or the brother-in-law might say, hey, I want the money, and then you want to start fighting with your brother-in-law. Make sure that those are considerations that the seller have to have. We are not lawyers, so we don't give legal advice. We are not CPAs, we don't give tax advice. We are not carpenters, so we don't give wood advice. We are not termite people, we are not plumbers, we are not roofers. We do not give people the advice that another licensed professional can give. We can only give real estate information. That house sold for $10,000. That house sold for $20,000. The interest rate, I can't give it to you. The lender has to give it to you, okay? So be careful as to what you can say and what you cannot say. Post-sale protections, right? So make sure that you include a home warranty on the property so that way the buyer don't come back to you. Safety precaution, don't leave your money, your guns, because there will be visitors coming to the house, okay? You are advised that you, not the broker, is responsible for fees and costs. When you are in escrow, the seller will be paying other costs to make sure that the transaction goes through, okay? Recording fees, maybe your lender has other fees that they're gonna charge you to pay off your loan. All of those fees are charged to the seller, not to the broker, okay? In the event that there are other items, you can always type them here. Sally will sign, Coldwell Banker, George Realty, Cesar Aviles will sign, and that will be the seller's advisory. Advisory, remember, is grandma telling you not to go out at night. It's too dark outside. Because California, it's a consumer state now, starting January of this year, the California Consumer Privacy Act will have a civil code that we tell the people that they have the rights to be private, that we cannot disseminate their personal information. So all of that information needs to be given to the seller. The seller will sign over here. So we look for Sally. Signs over here, she dates the contract, and we keep that in our documentation on our listing agreement, okay? I am going to go and see if there is anybody that have typed out a question on the chat room. I am going to stop sharing my screen and then I'll come back to the screen, but let me see if there is any questions at the present time. Any questions? It says here, good morning, well, CBGR Realty, it's a good class. So Ivy, thank you, Ivy. Anybody has a question, you can unmute yourself. Anybody has a question? We got 30 some people in the class. I appreciate you guys coming to learn. But remember one thing I want you to take away with you guys. It is Friday, it is the weekend. If you have nothing to do tonight, pay attention, create a listing. I don't know, list your own home and then throw away the paperwork. Don't print it, okay? Take a listing, make sure that you fill in everything about your house, the price, the square footage, the description. If you were to sell your home today, how would you do a contract? I don't know, put your wife, your boyfriend as a seller and put yourself as the agent, and then make a practice of doing all the documentation. The more you do it, the quicker that you become very, I would say, comfortable with all the documentation, and you are not going to be nervous when you're in front of a seller. Believe me, I still take listings from friends or past clients, and if I were to prepare all the documentation when I am in front of the seller, even though it's a past client or a friend of mine or a family, you still get a little nervous about doing it. Am I doing it right? You know, so if you don't practice and you only go to one listing presentation once in a while, you're gonna look like you do not know how to do this, and the seller will not want to pay you your full commission. That is the reason why I always demand 6%, 5%, because I go very, you know, I know what I'm doing. You need to be pretty confident. I don't know if you watch the news or you watch the newspaper, I mean the advertising that says, my name is Larry H. Parker and I'll fight for you. You know, those attorneys that are always fighting the insurance company, they always sound so convincing. That's how you have to be when you are in front of a seller, okay? You have to be so convinced, confident that you are the only agent that they can list with. Very confident, okay? So I'm gonna go back to sharing my screen if I have no questions, and then I'll have questions at the end. Oh, explain tax withholding again, okay? Somebody's asking me what the tax withholding. It is pretty hard. It will have to be, you take the seller to their accountant. Some people have the taxes on the FERPTA is what you're referring to. So what happened is the following. I lived in California. I am a taxpayer. Once I sell my house, I will fill in the FERPTA saying I am a taxpayer. My social security number is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And you don't have to worry, Mr. Buyer. That's my majority of the people. But in the event that the seller of this property is a foreign person, somebody that comes in from, you know, Brazil, or somebody that lives in Jamaica or Indonesia, and they happen to own a property in California and they are not citizens or legal residents in the United States, they pay taxes at a different rate. And the buyer has to tell the escrow, please withhold money. And it used to be pretty easy. It used to be 10% to the federal government, and it used to be 3 and
Jálale la
1/3.
oreja por mí. Jálale la oreja por
And
mí.
it used to be 10% to the federal government, and it used to be 3.3% to the state of California. Now it has gotten more difficult. And if you wanted to take a look at it on the back of the FERPTA, there is all kinds of rules. And I'm gonna go to that document on the back of, maybe I should go that one. So let me share my screen. And I'm going to go back and I'm gonna look for the FERPTA, Seller's Affidavit of Non-Foreign Status. And this one, it's a declaration by the seller that I am not a non-resident for purpose of US taxation. And the seller will have to check the box. We cannot do that for them. And my social security number is, and I put my taxpayer ID number, and I put my telephone number, and I sign it. So when I have this form, I am not subject to withholding. And there's also the California withholding law. Sellers agreed to provide escrow with the necessary information to comply with California withholding law, right? That's a taxation code 1A662. If you wanted to read it, you can go to that one. If you happen to be a foreign person, they will send money to the federal government, IRS, and to the Franchise Tax Board, California. And it depends on how much money you're making and how long have you stayed in the United States. So if you go to the back page, is the most confusing laws, because here it is, they're trying to determine who has a green card test, if somebody's been in the country more than 183 days. I mean, there's all kinds of craziness. How the politicians write the law, it still beats me. They have all kinds of things. Look at it, days of presence. I'll put a big one, right? But look at this one. That's the FERPTA. But look at this one, green card test. Well, I am not an immigration officer. It says an alien of a U.S. resident individual was a lawful permanent resident of the United States at any time during the calendar year. This is known as a green card test. Substantial presence test. An alien is considered a U.S. resident if the individual meets the substantial presence test for the calendar year. You need to live 183 days. Or 1/3 of the number day. I mean, it is so confusing. 1/6 of the number of day present in the second preceding year. I mean, I have to check on these people's passport to see when they came in, when they left, give me a ticket from, China Air, finding out what day did you leave the country, what day did you left the country. Look at this one, days of presence in the United States test. Generally, a person is treated as a physically present in the country at the time during the day. However, if a person regularly commutes, they go to, they come from London, from a residence in Canada, or this is from a Canada or Mexico, or is in transit between 2 points outside the United States and is physically present in the country for less than 24 hours, he is not treated as present in the United States. So if you come in, from Tijuana and go to San Diego and you come back to Tijuana tonight, it doesn't count like you've been in the United States. So I don't understand that, right? If you live in Canada and you go to Niagara Falls on the US side and you come back before night, you haven't been in the United States. So I don't know how this works. So you have to ask an accountant to really look at this when you are dealing with a foreign person, okay?
Cesar.
Now,
yeah, I have a question.
Yeah.
The seller, I had a transaction where the seller was a trust. And of course, the maker of that trust or the trustor was deceased. So the successor is the one that sold the property. But escrow did do the withholding.
I believe that they shouldn't, because the trust is a U.S. entity.
Okay.
What they could have done is you could have go to a tax ID, a lawyer, a tax accountant, I'm sorry, and calculate what was the tax liability and try to get an exemption, and they can do that. There is a form to do that.
Okay.
Now, this is for federal, but also for state. Let's say that I lived in Nevada and I bought a house in California. I never lived in California, or I live in California and I left California, and then I want to sell this property in California. California is going to tax you, and they're going to say, well, you live in Nevada now. We need to have a withholding.
Cesar.
Yes, sir.
I want to comment on the trust. If somebody die, or and if the property is is listed under the trustee can come in and take over automatically. Then you don't need to have withholding according to the FIRTA.
Okay, so Mary, the answer would have been that the property will transfer to the name of the trustee, and then the trustee will sell the property.
That's correct.
Right, that's what happened, but the escrow still withheld the money, and then I would check with the escrow company and they would refer me to the tax person. I would talk to the tax person and they'd refer me back to escrow.
Yeah.
Interesting. Yeah, that's what I understand. If the trustee took over, if the trustee has already has the title, because when the grantor die, you immediately file the affidavit of the death of trustee, and then the new trustee will come take over and you know and then transact according to just like the grantor.
Okay.
And you shouldn't have to you know, they shouldn't have to have the tax withheld.
Okay, but to get the money back, I should see the tax person.
Yes.
Yes, and you have to file. You have to file income taxes. Exactly.
Yeah.
Okay, great. Thank you.
Yeah.
Thank you, Peter.
Sure, you're welcome.
So the next document, okay, we go back and we end up going to Coldwell Banker Church Realty Addendum. I'm just going to touch on this one. It is a document that everybody should do. It protects us beyond all the other forms. It talks about the buyers. If you were representing the buyer, it will talk about the buyer's subsequent purchase to protect our commission. We again tell the buyer to do inspections. We also wash our hands and say, hey, Mr. Buyer, Mr. Seller, we are not responsible to determine the value of the property. Also, we talk about the transaction related services. We tell them that we are not responsible for the actions of the title company, the escrow company, all the companies that are involved in NHD, the home warranty. Coldwell Banker George Realty is not responsible for the acts of those companies. Also, we let them know that there is additional environmental hazards, 1031 exchange. We let them know sometimes people buy property where they own in partnerships, and maybe the one party is living in the property and the other party is living someplace else, and that party may be subject to 1031 exchange because it's an investment property for them. They never lived in the house, but we cannot determine that. I don't know what they claim on their income taxes. So we refer them to go see a CPA. Again, Coldwell Banker Church Realty reminds the buyers and the sellers that we do not give tax or legal advices. So when you're selling a property, you might have some legal or tax consequences. So please make sure that you consult the appropriate professional. In the old days, of course, rent control was just spotted in some parts of California. Now more than ever, the entire state is in a rent control. So we need to tell the people, hey, when you're buying a property thinking, oh, I'm going to buy it for $1 and I'm going to rent it out for $1 million. Hello, you may have to follow the rules in the state of California not to exceed the 5% plus the cost of living, the CPU. Here on item number 9, yes, we do tell them that Coldwell Banker George Realty charges $295 to store and to keep abreast of all the forms that are available in our file, the FERPTA, the transfer disclosure, the earthquake safety. We will keep that documentation, and then we tell them that we charge. We use this document to send it to the escrow to collect the $295 amount. Also, in the event that the seller is doing financing, we advise them that they want to hold Coldwell Banker George Realty harmless, you know, from creating a legal deed of trust and a note. We're not the people, we're not bankers, you know, on doing that. Same thing goes with zoning. I'm going to buy the property and I'm going to build a skyscraper. Well, you might be buying in an area where they don't let you build a skyscraper. The city would not let you change it from residential to commercial or vice versa. If this was an REO, short sale, probate, or trust, buyers are made aware that some of these sellers or financial institutions are exempt from obligations or disclosures. So you're buying and taking a greater risk. So we tell the buyer, hey, you better understand, go talk to your lawyer. Some people do not know in some parts that the aircraft noise, the noise from airplanes, or the train noise or the freeway noise or rural wildlife. You know, we have coyotes in San Gabriel. We got rats in Alhambra as big as the one from New York. They're hanging from the electricity wires. So we need to tell the people that there's wildlife in your neighborhood, or there's winds, right? Some parts of Puente Hills and Monterey Park were landfills. Please keep quiet.
This instance where we're at, right? So as an MLS subscriber, you can search under coming soon, right? If you forget that you have a
hold on a second, let me see if I can.
3 weeks, it goes automatically into active, right?
Okay, sorry guys, but anyway, we mute them. There is landfills in Monterey Park and Puente. Privacy notice, the same thing. Look at it. California just came in with today's. We prepared this form back in, I don't know, 2010 or 2006. I don't know how long we've been using our form. It was revised in 2018, but we let them know privacy notice. You know, we do not disclose personal confidential information to anyone outside of the company and outside your transaction. Also, we tell the buyers that the vesting, we Coldwell Banker do not give, go seek your lawyer to tell you how you will be holding title. So this form needs to be signed by the buyers and the sellers at the time of the transaction. We would like to get it signed ahead of time. The next one is the representative capacity form, the disclosure form in the event that here will be a company, right, a corporation. Then here you have to put entity, then here is a corporation, and let's say Peter Cam is signing on behalf of that corporation, right? The same thing could happen if this is a trust. You put the trust name and then the trustee. You know, Mary Scott is the trustee of the ABC Trust. So you can do that part. Or power of attorney, right? Lori's brother, Lori's sister is out in another country, and she said, Lori, can you please help me? And I'm gonna send you a part of attorney. So Lori is gonna be acting on behalf of her sister, right? You can put here, you know, sister. Sister is in Hong Kong, and I have the power of attorney to act on behalf of my sister. So I'm gonna be signing here on behalf of my sister. Or maybe I'm the administrator, the conservatorship, or the guardianship of a state. Somebody die, and so I am the seller is a state. I'm gonna put over here, you know, the state of the deceased person, with whoever that person was. Or if I am acting on behalf of a guardianship, a child, or somebody that is a minor, I will put the name of the minor over here, and I'm acting on behalf of that child. Or if somebody is, you know, disabled and cannot handle their proper affairs, I am the conservator of the conservatorship. Okay, this is the form that we needed. And then there is one at the time of the listing you sign. At the time of the sale, the buyer gets notified, and the other party needs to be signing this form as well. You need to provide this form to the other party and letting them know that the person that they're dealing with is a representative of that entity, okay? The next documentation is, we already discussed it, the FERPTA, that goes into our files. is supposedly be signed at the time of taking the listing. If somebody says, Caesar, I don't know, I'm gonna talk to my accountant, I'm gonna give it to you, it is fine. At the time of escrow, escrow will do a qualified substitute. This one is an escrow company will say, don't worry, Mr. Buyer, I already have a copy of the seller's social security number, and they told me that they are not subject to withholdings. That's why the escrow company in Mary's case was overly zealous on withholding money. Maybe they did not understand, and they felt like, I better send the money to the government and let the seller handle it themselves, because I'm afraid that they're gonna come back after me. Technically, the law says that they can go after the escrow if they make a mistake for not withholding, okay? So, but in this case, if I have the FERPTA, then I could always delete it. I'm gonna delete one FERPTA because I don't have a husband. If you have a husband and wife, each one have to fill it in. If you have two people on title, three people on title, each person on title will have to fill in this. I'm gonna be using FERPTA, then I don't need the qualified substitute, but I can use either or the escrow company, sometimes they type up their own, and that is okay for our file. As long as we have something regarding FERPTA in our file, we did our job, okay? The next document that we're gonna do is called market condition advisory. We're telling the seller that we do not tell them how much money to ask for the property, right? There will be inspection contingencies. The broker recommend that you do not write non-contingent offers. This is one of the recommendations for the buyer. We also tell them there could be multiple offers and there's competition. Also, Mr. Seller, you are responsible for determining the asking price of your property. We are not the ones. So we let the buyer know what they're getting into. Today's market is pretty hot. So you need to let the buyer be aware that the market goes up and down, and we are not responsible to set the price of property. Make sure that you always date the documents. Always, 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 you gotta date the documents, and always, always, always make sure that you get the client's signature. You know, it's best to get it at the time of taking the listing. Sometimes if you think that the presentation went too long, you could always take the listing and then come back the following day with the excuse that you're gonna be putting a little for sale sign, or that you're gonna be taking some notes on your AVID, and then bring all the paperwork and say sign, sign, sign. Or you can leave it with them on the night of taking the listing, walk out with the agency and the listing, and then come back the following day to take pictures and pick up all the papers signed. I'm gonna leave them for you to sign them, to read them, and have your husband and yourself to sign them. I'm coming to pick them up tomorrow. You can decide on how to do that. The best way to work your schedule is the best way. You will create habits, and better create good habits than bad ones, okay? So make sure that all the papers signed within the first day, the next day after you take the listing. So this one will be the market condition advisory. It has to be signed by the seller. The next document that we have is a water conserving plumbing fixture carbon monoxide notice. Okay, so this one, it became in effect, I believe in 2014. And it says that anything that was built before 1994 has to be equipped with water conserving plumbing fixtures. Okay, the only problem that I have with this one is that the seller doesn't have to comply with it unless it's asked in the purchase agreement. And they can tell somebody, hey, yes, my house doesn't have a water conserving plumbing fixtures. When you become the buyer, when you become the owner, it's up to you. You can change to any faucet you want, any type of toilet you want, any type of shower head. For example, I have a big shower head in my shower. I love a lot of water to fall in my face when I want to wake up. And it is in violation of this civil code in the state of California. I don't care. No police is going to my house and check my I don't let them come into my bathroom, okay? So when I sell my house, I just let the buyer know, hey, you better change it and make it a water conserving if you happen to be concerned about water. I am not, okay? The same thing goes with carbon monoxide detectors, right? The law says that every property has to have carbon monoxide detector if they have fuel, right? Gas property. If it's an all electric property, does not require this, okay? So if it's an electric, there is an exemption, okay? So there is no requirement for a carbon monoxide if the property is electric, okay? There is violation, they charge you $200 for a violation. So nobody have knocked on my door yet, and I won't let them come into my house anyway. Until that happens, I'm not changing my shower head. But you need to notify the buyer of the law that exists in the state of California, okay? That's what this paper is all about. My suggestion is read it. If you wanted to be in depth with this transaction, make sure that you read the civil codes right there. The numbers are civil code there. You're going to go to the health and safety code and go read all those things, and you become very knowledgeable about the law. But in my opinion, I get it. I give it to the buyer. I tell him, you sign it, put it on my file. The next document that it is we touch a little bit on the lead base. Okay, every property that is built before 1978 may have been painted with a lead paint. Okay, and so the federal government requires that we notify the buyer of the potential of lead in the property. The listing agent signs, and then the buyer signs, and then the buyer's agent will sign the form, okay? This form is exempt if the property was built after, and for any reason you are on SkySlope, and it says that we need to have the lead. All I need you to put on SkySlope is year built, 2004, and I will not bug you anymore, okay? So for those of you that think that you have to go and create this form just to comply with the SkySlope, don't do that, okay? No need to have the form. So this doesn't apply. So imagine that I'm selling this house, and Sally's house on Valencia was built last year. All I need to do with the form, I come over here and I said, lead-based paint doesn't apply. I'm gonna delete it. Does not belong in my transaction, period. That's all you need to do. You make that decision, right? The next form that we have is the earthquake hazard report, okay? This one is the questionnaire, okay? Guys, some of you are still using version 2005. That was 15 years ago. I was a young man then, okay? Now I'm older, it's 2020, okay? So make sure that if you're taking a listing today, you use the proper year. I'm still allowing, because it is a new form, if somebody took a listing in December and we sell it now, if somebody took a listing in January or February and we see the 2005, I'm letting it go by, okay? It's, but you should start using the 2020 edition, because some of the changes are question number 8 and question number 9, okay? If anybody know who is Mr. Alquist or Mr. Pirolo, they were the ones, assembly people that created that law. And this one, do you know if your property is on a seismic hazard zone? This is gonna be on the NHD report, okay? Please, 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 don't make a line like this. Don't know, don't know, don't know, don't know. You agents are supposed to know, and the buyers and sellers need to read this and take a look at the page of the book, and there is a picture, okay? And there is a picture, so you can say, if your property built on a hillside, you can answer no.
睡觉前看肿的好厉害，好大的那个哦，很厉害。
Okay, sorry for the interruption. This form has a new, the seller has to sign Sally, and then we're gonna give this form to the buyer's agent to get the buyer's signature, and we will put it in our file, okay? Now, if you guys want to email the guide, the earthquake guide, it's right here, okay? This one is the receipt of that form, okay? So any buyer, regardless if the property was built yesterday or if the property was built 100 years ago, a buyer for Coldwell Banker George Realty must have it, okay? In the event that you're taking a listing and the property is built after 1960, 1960 is the threshold. So if the house is built in 1961, there is no need for the earthquake hazards report. Just because the sky slope requires one, you can say property built in 1969, and there will be no requirement for the hazard report. We still need to have the signature that the buyer got the guide, okay? Kind of like when you buy a car, they give you the car manual. That's what this one is about. It's a government manual about earthquakes, about asbestos, about formaldehyde, about all of those chemicals that may be found in construction materials that can cause cancer. You know, Proposition 65, I don't know. It is known to the state of California that if you pump gas, you're gonna die of cancer. Who knows what it is? Or if you're pregnant and you drink alcohol, you are going to have birth defects in your child. Whatever those statements that are there for a reason, we need to give the booklet to the buyer. If I click here, it's a PDF of the booklet. It's 100 and so many pages. Please do not get it. You could always email it from here. If you want to email it, you can do it right here. Send it by mail, email, and you can send it to your customer. You don't need to print it. Please don't waste ink. Another document that the seller needs to fill in is the statewide buyers and sellers advisory. Those that have come into my classes, I tell you that if you read this several times, you are going to know more real estate than 90% of the people that are in the real estate business. It talks about everything and anything. It is cut into 3 sections: buyer's rights and duties, the seller's rights and duties, and then the broker's rights and duties. Read this part. That way you will know that the broker do not have an expertise in all areas of matters affecting property. For most sales of residential property with no more than 4 units, brokers have a duty to make a reasonable, competent, and diligent inspection. That means you need to do the AVID. Many defects and conditions may not be discoverable by the broker, so don't blame it on us. If the broker gives a referral to another professional, broker do not guarantee that the person's performance. You might select any professional of your own choosing. So these are the rights and duties of the broker. Over here is everything that you need to know, and what you need to do is paraphrase it. Investigation of property physical condition, easements, environmental hazards, formaldehyde, geological hazards, inspections, mold, pets and animals, septic systems, right? Soil and geological conditions of a property, square footage, lot size, boundaries, and surveys. Read this paragraph, and when people ask you about is this the boundary of my property? You say, nobody knows where is the boundary of your property. If you need to know, you need to hire a professional surveyor that is gonna be marking the corners, and they're gonna make you sign a paper that says that the survey is only good for a certain amount of time because we have earthquakes and the earth move. Okay, so always make sure that they read and understand that we cannot guarantee the square footage. There are different sources. The assessors has one source, the builder has another source, the appraiser have another source, so be careful with square footages. Water problems, wells and water systems, okay? Let me see if I can get, having fun, Ivy. So anyway, I tell you about wood destroying and pests. That would be the, sorry, I should have used the so that way you can read it. Septic system, soil geological condition, square footage, water intrusion, wells and water systems, wood destroying pests. This is what we regards as termites, right? Wood destroying pests is termites. Property use and ownership. So now they go to the legal, accessory dwelling unit. Building permits, a lot of questions about whether something is, if it's without permit, is the city gonna destroy it? The answer is no. You might just need to go and pay for the permit because that's what the city wants, just their fees, and they'll have it inspected and now you have it legal. A lot of people do things without permits because they do not want to have their home reassessed. Meaning if I build another bedroom, then the county comes up and say you owe more taxes. And so people didn't want to do that. So they build a lot of stuff without the permits, but they build them with a nice builder, nice window. So all they need to do is legalize those properties. And now with the ADU units, you can legalize a lot of buildings that were done without the proper permit. All you need to do is give a drawing to the city pay the fee, and they go and do an inspection, and then they approve it. If there is some modifications, then you have to make those modifications and changes. California Fair Plan, a lot of people probably in Monrovia, Duarte will have to get insurance from the Fair Plan, which is the government plan, because private insurance companies may not be having the money to risk in the fire zone. Future repairs, replacements, remodels. Heating, ventilating, air conditioning systems. Guys, remember that there is a law after January 1 in the state of California that some of the Freon, the R22, whatever your old air conditioning may use, no longer is available for sale in the state of California. So there are only a couple of old companies that still have it. They might repair your system, but watch out, it's a new law. You might have to replace your air conditioning. If your property is a historical designation, coastal commission, if you live by the beach, worry about the birds and all that views. They have rules in the coastal areas of California, okay? Insurance, title insurance. There's an explanation about all that. Marijuana, cannabis, methamphetamine labs. There is a whole paragraph about that. Owner's title insurance, right? It tells you you should be getting title insurance. There are rules. Rent and eviction controls. Right now, guys, I mean, we have a new eviction problems with the COVID-19 rules. There is a new law in the state of California where you cannot evict people, and also the courts are closed. So make sure that you tell people that if they're buying a house with a tenant, they're gonna run into a problem of evicting somebody. It's not as easy, okay? I wouldn't recommend for you to do it by yourself or even for you to explain it. You need to get an expert lawyer. Don't get a divorce lawyer to do that because he might not read or understand that. You gotta get a landlord tenant, a special lawyer, okay? Retrofit building requirements, point of sale, so you know that. Short-term views, swimming pool, security, safety. I mean, this is an entire real estate class on the entire form of golf course disclosures. If the property is close to a golf course and a ball hits you on the head, well, who's the liability? Okay, neighborhood, personal factors. I mean, I might be, you know, I might don't wanna live next to a cemetery, cell phone towers. People are, you know, or electrical wires, you know, drones, right? Drones right here. There might be an area where drones are gonna be flying on top of your head, who knows? Neighborhood noise, schools, underground pipelines, legal requirements, death on the property, earthquake zones. I mean, this is an entire 14 pages of mumble jumble legal stuff that the property owners need to know. So be aware and give it to the clients so they can learn this stuff. To me, this form, I would give it to the buyers. When I meet the buyer, I say, hi, take a look at this document. We're gonna be signing this document once you buy the house. Pay attention to all of this before we write up an offer. It may be a good document that you're looking after your buyers, you know? If I were a buyer's agent, I will give this form and I would use the agency form even before writing an offer. When I start showing them property, when I pre-qualifying for a loan, I will give them this form and say, read this form, and this is what you're getting into, okay? The seller is gonna sign it, and then the buyer is gonna sign the document. The selling company, the selling broker is gonna do it, and then, which is the buyer's agent, and then the listing company, which is the seller's broker, will have to sign the form. Everybody signs it. 14 pages of just rules of to the houses, okay? It's called the Statewide Buyers and Sellers Advisory. It's an advisory. So, Mr. Buyer, this is what you're buying. Mr. Seller, this is what you're selling, okay? We go back. The other document that is pretty required is the seller property questionnaire. I'm gonna move very fast because we only have 10 minutes. And then next Friday, there will be no class because I'm gonna be out of town. I'm taking a few days off and I go see my son in Portland. Maybe I go burn some buildings. I'm sorry, I didn't mean that. Okay, but then I'm gonna go to seller property questionnaire. It's the questionnaire to the seller. Seller needs to tell the buyer whether he knows of the property, anything that the seller knows about the property, he needs to disclose to the buyer. We don't fill it in. If you email this form to the sellers will be unlocked and they can check yes or no. If you print the form, it will also be unlocked and then you can fill in the information and answer yes or no and then scan the form and they get Sally to sign it. But it is a lot of questions about and I use this form after the statewide buyers and sellers because some of the explanations were done in the other form, and then the sellers will be able to answer these questions yes or no based on what they know about real estate. Like for example, look at this one, disaster relief. Some of the people in Duarte, Monrovia, because of the fire, may get some of the disaster relief, any civil settlement. This is when there is riots on the street. That could happen on some properties in some of the downtown areas where there were some vandalism or whatever. Pets, animals. We think that our little pooch has no problem, right? No, you need to tell the buyer whether you had a pet on your property, right? You know, they pee on the carpet. There may be some others, some allergies if you have cats or snakes or lizards, who knows, or hamsters. Landscape, pool area. So the seller needs to say yes or no. If he answers yes, he needs to write an explanation. Okay, that is called the seller's property questionnaire. It's part of the listing agreement. The next one is the transfer disclosure statement. It's code, civil code. It's by the law. The seller has to tell the buyer if the property has these items and if there is any problems with those items. You can sell a house with a no dishwasher, with a broken window, with roof leaking, as long as you tell the buyer the hot tub doesn't work, the central air conditioning is disconnected, the exterior walls are broken, the electrical system, the lights don't work. I built the house without permit. Yes, yes, yes. All of these you can answer yes, yes, yes. And the buyer will buy the house as long as the buyer is aware that there are problems with the neighborhood noise, nuisances, you know, gang members on the street, right? Sometimes you need to tell that there is a marijuana selling house, that the police goes to that house every weekend. They have parties. They got the mariachi going at 3 o'clock in the morning every Friday, every Saturday. You need to tell the next buyer using the real estate transfer disclosure form. Cannot get away from it. Then is the agent visual inspection disclosure. This is you doing your duty, right? Civil Code 2079. The agent have to do a reasonable inspection. Doesn't mean that you have to go under the house or you have to go to the roof. But if you walk through the living room, you may say, the floor, you know, slippery or whatever. I have a torn carpet. You might be in the dining room and all of a sudden you find out that they have new windows or anything that you can see on the property. Kitchen, you can say, you know, new cabinets. You use this form not just to call out defects, but you call things that you notice about the house. It is not a marketing form that you're gonna say, oh, beautiful kitchen cabinets with marble. No, no, no. It's just something that you mentioned on the form that you found out. Bathroom number 1, bathroom number 2, you can say shower door broken or no shower door, or one side is there and the other side is not there, or the toilet is leaking. I mean, it has no tank. You can do whatever you want. It is your inspection. Seller have to sign, buyer have to sign, the other agent have to sign. And if you are representing the seller, you do that. If the buyer's agent does one for himself, then you would have to have everybody sign. So every file should have 2. The listing agent's inspection, AVID, and the selling agent inspection, AVID, signed by the 4 people, buyer, seller, buyer's agent, seller's agent. A lot of times, some of you are not doing it. You're only doing once. Please don't do that. The next form that we need to do there is the disclosure information advisory. This one is just an advisory to the seller to tell the truth, that he needs to complete the TDS, that he needs to complete an NHD, that he needs to comply with the civil law. So we are telling the seller, hey, Mr. Seller, please fill out your property questionnaire to the best of your knowledge. Mr. Seller, in the event that is exempt, in case there is a trust, no TDS, and then some recommendations that we give to the seller signs it, and that completes all of the forms that we need at the time of the listing. Some of the other forms that are here are the seller counteroffer, seller multiple counteroffer, modification of terms. If you're gonna drop the price, you're gonna use those forms. You don't need them at the time of the listing, okay? I am going to stop the sharing, and then I'm gonna open up for some last questions because it's almost 12 o'clock and I owe you to get out of the class on time. It took me a little longer this time, but not next week. The following week, I'm gonna maybe, if you tell me which form you like to, which disclosure, I'm gonna do the transfer disclosure statement, AVID. I'm gonna go over the FERPTA again next class, and I'm gonna take a little bit longer time. Instead of the listing agreement, I'm gonna do it on the disclosures on not next Friday, but the following Friday in September, okay? September the 18th. Any question?
Cesar.
Yes, Thomas.
The in regards to the DigiSign, digital signature.
Yes.
Do you remember that transaction where the escrow company was requesting a certification that the buyer's signature were valid? That seems to be the case lately. Have you run into that lately with other agents?
I had one escrow company requesting, and you could ask Anna, if you do digital ink and you go to the folder, there is a document there that is the certification, and you can email that to them and say who did it, okay?
I see. But that's becoming very common from the escrow company to request that?
You know what? Maybe somebody got in trouble, and now that escrow company is using it as a way to protect themselves. See, there is no problem, and nobody needs it until somebody needs it. And then when somebody needs it, then ask every time to cover their butt.
Right, okay.
I have here, you're welcome, Daniel. I love it when you come in. He says, thank you for revised document. Wonderful time, update our knowledge. Thank you for Daniel. There is a question here. Do we prepare the listing contract and disclosures with the power of attorney's name or the owner's name as the POA is signing and their own name on the property profile? Technically, the question is, you prepare the form as the owner's name. So if your sister is in Hong Kong and your sister wants to sell the property, and your sister goes to the American Embassy and sends you a power of attorney that says, you can act on my behalf, okay? So that person is gonna sign sister's name by Cesar Aviles, her attorney in fact. That's how it's supposed to be. Did that answer your question? Thank you. So the seller's name is the trust. The representative agreement says Aviles Family Trust, and then Cesar Aviles trustee. If it is a conservatorship, it's gonna say, in the matter of the conservatorship of, you know, John Smith, that he's in a convalescent home. No, it won't say that he's in a convalescent home, but they will say Cesar Aviles, conservator, right? If you are doing that, the name of the person that is on the convalescent will be the seller's name on the property. I mean, they're the owners. I am just acting as a representative of that entity, okay? And remember that if you make a little mistake on this documentation, it's not so critical. Sometimes we might have only 2 sellers, and we didn't know that there was a 3rd seller. Nobody told us, and all of a sudden in escrow and the prelim, they say that the seller number 1, seller number 2, and then all of a sudden we have a seller number 3. Escrow can get the name of the seller added to the transaction and get the 3 signatures notarized, and clear title will transfer. So if we didn't have it at the time of the listing, all 3 names, legal name, you know, like my name used to be Cesar Jose Aviles Pineda. That was my name in my country, right? Now it's only Cesar Aviles. That's it. And I could have taken title with a middle name. My son's name is the same as my name. My father's name is also Cesar Aviles. So if we own property, I had problems, and then we have to get a declaration, a statement, and then have to be signed by everybody. Any questions? Things can be fixed in the escrow. That's the purpose of the escrow. It is a time to make sure that everything gets clear, okay? And then title company ensure that everything is clear, and the escrow person supposed to be a middle person. You get the money, you get the title, and the escrow company switches. You take the property and you take the money, okay? Anything else? Any questions? Jennifer? Okay, well, it is 12:04 in my clock. I want to thank every single one of you. We had a lot of participation. I love to help you as much as I can. Lori, Peter, Doug, all the staff is here to help you. We want to make more transactions. So that's the reason why we're going to keep up all this training. I am going to make a modification. I'm going to start changing it because it seems like the same people come into the training, and I'm going to be adding other items to the training calendar. So instead of doing it once a month that we're going to be doing working with buyers, then once a month working with seller, once a month disclosure, once a month real estate practice, I'm going to be including other classes, and maybe it's going to take us a 2 months rotation, like 8 weeks. You will know everything that you need to know in real estate, okay? My pleasure. Have a wonderful weekend. I'll see you on Monday for the sales meeting. For those of you that are in Alhambra, have a wonderful, wonderful week. Next Friday, no training. I'm going to be in Portland. Thank you. Bye-bye.
This is